We're super excited. Yeah, I can just see your virtual background, Sammy. Does your audio work? Do you want to do audio? Everybody in.
Hey, Rachel, can you hear me?
I can hear you!
Awesome.
That's good.
The bank security system is not allowing for the video display, so I apologize.
Oh, that's okay. I'm glad we can still hear you. That's exciting.
Great.
And thank you for still being a sponsor, even though your bank doesn't let you use video. We appreciate it.
You're welcome. Glad to be part of the chapter event.
Thank you, Sammy. It's good to hear your voice too. Oh, I miss everybody. It was hard for me. Okay. Okay. And if Ken Carteron is in here somewhere and wants to turn on his voice, feel free. Okay. Oh, they're still coming. I mean, maybe we should start. What do you think, Jeff? Should we give them another?
I think we could probably start. People will join if you're able to just continue to let them come.
Mm-hmm. You got it. I will manage that for you.
From
No
the meeting
problem.
room. Allison, are you in Scotland?
I am not in Scotland. I wish.
Okay. So first of all, thanks everyone for coming into the program today, and welcome to our first full hour digital education program. That is for the CAI CNC chapter. My name is Jeff Brown. I am one of your directors for 2020, and a last minute replacement due to personal reasons. Jennifer Richardson's not able to be with us, but I'm glad to fill in, and I'll do my best to make sure that the program runs smoothly. It's going to be a little bit of a new adventure for many of us, so we appreciate your patience and bear with us. We have quite a few board members on the call today. I'll list some of them. John Hanson, who's our president-elect for 2021. Scott Hubbard, Betsy Ledesma, Mark Glassberg, Miranda Ward, Richard Navarez, Dan Young, and of course myself. The CNC board has spent a lot of time making sure we're communicating with you during this time. If you have any questions, please reach out to any of us. We're glad to try and fill in the gaps. I know there's a lot of them. And we couldn't make any of this possible without our event sustaining sponsors. So the first thing I'd like to do is let them have a couple of seconds to say hello to you all. And John, if you want to take the first role, John Checks from Checks Law.
Certainly, guys. Hey, want to welcome everybody. It's good not to see you, but see you, if you know what I mean. I guess welcome to the first remote luncheon. I think we're all kind of chartering new paths here. I feel the sky is kind of clearing with businesses getting back. Our boards seem to be meeting. We're doing our inspections, et cetera. Our cases seem to be moving, but I just wanted to hope everyone's safe and wish everyone well and look forward to seeing everybody in person when we all resume. But my hat's off to the chapter and to the board for all of their efforts in trying to keep things normal as we move into the future here. So thanks for coming.
Thanks, John. Thanks for your sponsorship. We appreciate it.
Thank you.
Is there a representative from Mastercraft Painting? I don't see anyone on that I know. Ed?
Ed? No, Ed. We love Mastercraft. We really appreciate them.
Thank you. We appreciate your sponsorship too. Ken Carteron, I'm not sure if you're on, from Seacoast Commerce Bank, excuse me. No, an important sponsor for our chapter. Thank you for your sponsorship. I know Sammy's on the line somewhere. Sammy, introduce yourself.
I am here, Jeff. Thanks. You. Greetings, ladies and gentlemen, and thank you, Rachel, for getting us all connected virtually. It's always nice to connect virtually when you're not able to connect in person. Hope you're all staying healthy and safe. This is Sammy from Union Bank HOA Bank Services, Union Bank has been around for 150 years and specialized in the HOA industry for more than 30. We offer a full suite of HOA banking products and services, and we also offer integration with multiple accounting software packages to make your accounting much more efficient. As an essential business, like most, we are available for your banking needs during this unprecedented time. Please feel free to reach out to us. You can either reach out to me or Stephanie Shade, or you can find us in the membership directory, or simply visit our website at hoabankservices.com. Thank you, and I hope you guys enjoy the program.
Thank you, Sammy. We look forward to seeing you at our next live event, where we know you and Union Bank have been big supporters for many years. Thanks to all our event sponsors. We really appreciate you. And then, yeah, there, Rachel.
Sorry, now I'm going to go.
Of course, our other rock stars, the registration sponsors, we couldn't do this without you guys too. So let me just go through the registration sponsors and thank them. Alliance Association Bank, Angus and Terry LLP, Associate Northern California, the Stockton office. I know those guys. How are you? I hope you're all having a great time. Vidal and Jacobson LLP, Heritage Bank of Commerce, Mission Landscape, Pacific Western Bank, Progressive Painting, Real Manage, and River City Restoration. Thank you to all our sponsors. And please consider our sponsors when you're planning projects or need help in your community. They are the best of the best. So on to some housekeeping. We're recording this meeting in case anybody is concerned about that. We want to have it in our archives for anybody to reference in the future. We will actually have that available for you on YouTube shortly after we're finished. Please keep your microphone and your video on mute. We'll be taking questions via the chat function, which you can find at the bottom of your Zoom screen. Let me take a minute here just to talk about that. It could be a little hairy with a bunch of questions coming in for the attorneys. So I'm going to ask you, if you have a question for a specific attorney, to make sure you put that in the chat box as well. Otherwise, we'll probably do something like a rotating basis and then allow comments after by any attorney that wants to put their 2 cents in. And I'll do my very best to go through those and combine questions that are similar in nature so that we don't have too much redundancy here and we can keep the program moving. So finally, for anyone who misses seeing people, we'll be doing an impromptu networking session immediately after this program where everybody can turn their microphone and video on and you don't have to sign off right away. So stick around for that if you want to. Without further ado, let's get started. We're going to start today's program with a quick update from our advocate at the Capitol, Mr. Louis Brown. Thank you so much for joining us today. We know you're busy and we really appreciate your presence here, and tell us what you're doing, Louis.
Thank you, Jeff. And thank you everyone else for joining us today and staying involved. Very much appreciate that and hope everyone is healthy and sane. And it's hard to say sane when we're going to talk about the legislature, but they are still in session. When the pandemic was first declared, both houses of the legislature passed emergency funding for the governor and then went on a 5-week recess. They have now come back and both houses are moving through the legislative process in a much different fashion than we're used to, as is the case in most areas. The building is closed to the public, but legislators and staff are allowed to participate as needed when they're in legislative hearings. Our CLAC legislative agenda is much different looking right now than when we started the year, as one would expect. Most of our sponsored bills have been put to the side as a number of legislators have decided to scale their legislative packages down to really COVID-19 related or economic recovery related issues. But we still have work. There are bills that we're monitoring on an active basis to make sure that amendments don't get put into the bill that could have a detrimental impact on community associations. One in particular that we are actively working on is Assembly Bill 3182 by Assemblymember Phil Ting. This is a bill that would restrict an association's ability or prohibit an association from having any rental restrictions in their governing documents. We have been actively engaged on it. Allison Anderson is here, and she's the chair of our housing task force for CLAC. We've been working with the author's office on a regular basis. We think we are very close to some amendments that could resolve our issues with the bill, and at the same time provide some clear authority for associations to restrict short-term rentals. So this may actually turn into a win-win situation from a bill that started out as being really bad. So we're going to continue working on that. And like I said, continue to monitor a number of other bills. There will be significant discussion on housing and economic recovery. The state started with a $7 billion reserve. It is now forecast to have a $54 billion deficit over the next 2 fiscal years. So there are a lot of issues that we have to watch in the budget. Lastly, I'll say, Jeff, this is a great opportunity as we've all learned to utilize Zoom meetings. It makes it much easier for constituents, homeowner association boards, homeowners to reach their legislators. And we are actively putting together a legislative toolkit that we want to get out to all the chapters to encourage you to have those meetings with your legislators. They are now more than ever focused on their districts, focused on their constituents. And so meetings like this are pretty easy to put together with legislators. We were able to do some of them when AB 3182 went to the Housing Committee, and it was quite effective. And so if the Northern California chapter wants to do some of those and your LSC wants to make some of those happen, just let us know. We're happy to put those together. And like I said, legislators now are in tune with their districts more than ever. And this is a great opportunity for us to create new relationships, strengthen old relationships, but just stay in contact with those legislators so that they know that our issues are still important and keep them engaged. So with that, I want to say thank you for your leadership. Thank you for staying involved, and look forward to the rest of the program.
Awesome. Thank you so much, Louis. Great information in there. A tough row to hoe ahead of us, but you know, we've proven to be up to any adversity that we've had to come through so far this year, and I have great hopes that we'll be able to continue to do that. So very much appreciated. Now let's get into the educational panel a little bit. I'll take a few seconds for each of the participants and the attorneys to introduce themselves. So let's start up here in my left-hand corner, Roger Grant. Good morning.
Good morning, everyone. I'm Roger Grant with Fenton Grant Law Firm. Our firm practices in construction defect law, and I have a long history of general counsel law for homeowner associations, about 30 years. I'm glad to be with you all today.
Thanks, Roger. Great to have you with us. Allison, you're muted right now, but you. Good morning.
Good
Allison
morning.
Anderson.
I'm Allison Anderson, a partner at Angus & Terry, and I do both construction defect and corporate litigation.
Thank you. Let's move to Mr. Adrian Adams. Good morning, sir.
Good morning, everyone. I'm Adrian Adams with Adams Sterling, and we do corporate counsel work statewide for associations and are actively involved in CLAC.
So you are, and we appreciate all your involvement and your sponsorship. Thanks, Adrian. John Checks from Checks Law is there, but I can't see you.
Darren, you must be
John's
muted.
not part of the panel, so.
John's not part of the panel. That makes sense. Thank you, Darren. Darren Bevan from Vidalin and Jacobson is our final panel.
Yeah, and I'm, as you know, I'm Darren Bevan with the law firm of Vidalin and Jacobson. I'm a partner here with the firm, and we provide general counsel services throughout Northern California, both litigation and advisory. Also, just on behalf of my panelists, I want to remind everybody that this is a general discussion. So the information we're going to be discussing today is presented for general informational purposes only. Please don't construe anything that we say as being legal advice on any matter or answering any specific legal question you may have. It's important to remember that while we're going to try to ensure our accuracy, all of the orders are changing dramatically right now, and so the accuracy may be difficult. We cannot guarantee that any of this information is accurate. And you should be aware that this is going to be a constantly changing situation. And it's also going to vary by circumstance. So we'd ask you all, if you have specific issues on a given law or legal issue, that you communicate with your counsel on those issues. We ask that you not refrain or do something based on anything that we say today. But today is an opportunity for you to ask the questions that you've always wanted to ask without having to be charged. But ultimately, if you're going to make a decision or not do something because of something that we say today, please do not do that. Please rely on your own counsel. These are important times. It's important that we do the right things and that we get the right answers as best as we can under the circumstances. And with that, I think I'll turn it back over to Jeff and we can open this up to questions.
Right. Thank you, Darren. Full disclosure, as we expect from you, we do appreciate that. So I've asked for everybody to submit questions. I've got 1 or 2 coming in already. So here is a question, and actually the first 2 questions are basically the same, and this is one I'm sure that you all expected. What is the best practice currently with pools and the shelter in place order, and how do we safely open pools and amenities? Pretty general question.
Well, I just start addressing it that one is we have to be paying attention to our county orders. So the public health orders that are coming out of each county are going to vary. And I know Adrian's been speaking to this a lot as well. But one of the big things is just to keep in mind right now is in most counties in California, the pools that exist within the association's common area are typically considered to be a public swimming pool. And as a consequence, in most cases, those pools are currently closed. I think one of the reasons, and one of my other panelists, they want to chime in as well, I think one of the reasons there is that we should expect that the counties and possibly even the state will be issuing orders on how to reopen these pools. We've seen that in other states. So for example, last Friday in North Carolina, they issued procedures for reopening public pools, which are fairly lengthy, fairly detailed, and we should probably expect to see something similar to that either being issued by counties or even the state. Because currently right now the state does have an order that all public pools, which is a common area pool, as well as community centers, which are also known as clubhouses, are to remain closed during the current orders. With that, I don't know, Adrian, if you had any thoughts as well, because I know you've been tracking this a lot.
Yeah, I'll add to that. What's interesting is, as of yesterday, some of the counties got smart and they deemed HOA pools to be private pools, and therefore they could open, so that they wouldn't be in violation of the state's order that public pools be closed. And they've issued their own guidelines. Orange County, Los Angeles, Riverside, and other counties have issued their own guidelines on how those pools are to be opened. And they're similar, but they're not all consistent. And so you'll need to pay attention to your particular county and decide and follow their guidelines and on the reopening. So it's going to be an interesting, even though the state has defined all pools, including HOA pools, to be public, we've got now this conflict between counties who are defining them as private and the state defining them as public. And I think, the potential liability is minimal and that they can follow their county guidelines.
That's a lot of what we're seeing is that the liability should be low. I think one of the things too is keeping an eye out for large groups gathering, because I think, I don't know if the other attorneys on this are hearing the same rumors I'm hearing, is that there is risks that, people may be suing over potential infections. Keep to the county orders, stick to those procedures, try to maintain low numbers of people at the pool facilities, all good ideas under these circumstances.
So a follow-up question, Darren, or Adrian, or Allison, or Roger. Once we know what the guidelines will be, do you have any suggestions as to what the best methods of enforcement might be? In a general sense, of course.
Politeness. It's going to be difficult.
Enforcement is going to be very difficult, if not impossible. And I spoke with the manager who's opening their pool yesterday. And just like the flocks of people who went to the American River last weekend, everybody came to the pool. And they didn't want to hear that the pool was limited in numbers, or that the pool chairs had to be 6 feet apart, or you had to wear a mask. People just weren't complying. They go a little crazy when things open. So unless the association has the capability to station a pool monitor at every pool, it's going to be difficult, if not impossible, to enforce.
Right. I think there's a lot of questions here that I'm seeing on pools. What's your opinion, Allison, on whether a waiver signed by members would be sufficient protection for the HOA? I'm assuming that we're talking about those associations that are opening pools in contravention to their county guidelines.
Well, as Adrian said, I'm not sure that there is actually a ton of potential resulting liability if the association does not comply. It's going to, again, depend on the counties and how strictly they are enforcing the county orders. But having said that, if you look at some of the other areas or topics that that this crisis has impacted, it is definitely true that the counties and the state are coming out with some very specific orders about how to reopen things, construction being one of those topics. And so I think it's best to take a conservative approach, but Roger is right. Unless you are going to actually have somebody, on site monitoring the use of PPE, which is, kind of crazy if you think about that in the pool setting, performing some type of safety check before people are entering the pool area, I would stay away from it.
Is it even possible to enforce PPE requirements in a pool in a situation like that, masks and things like that?
Well, so some of us have been providing emergency board resolutions regarding the COVID-19 pandemic to our clients, and query whether, although the policy behind them is very good, query whether we can actually do some of the things that we've recommended. But to the extent that the county is requiring use of face masks, for example, I think that the association could enforce it if it has adopted that type of resolution. One thing that I will say is it is pretty crazy, and I know this problem exists specifically with regard to the pools, but it is pretty crazy when you start reading the actual orders where, in one paragraph it says the use of face masks is required, and 3 paragraphs later it is language that is suggestive of using face masks and not a requirement. So I think that with regard to face masks in particular, it's a little bit more problematic to enforce that type of.
Now, let me add to that, Jeff. I've read some of these orders, and some of them are just draconian. They're just ridiculous. It's really not possible for associations to comply with those orders. And frankly, I don't think a lot of the homeowners are going to put up with it either. So requirements that they wear face masks and wiping down everything every 5 minutes required by the association. It's just not going to happen. So I think what's going to occur, which is already happening with some of the associations I've talked to, is that they're simply posting the requirements, and then leaving it up to the owners to self-monitor. And those who want to wear a mask will, those who don't won't, those who are smart enough to wipe down the chair before they sit on it will do that. And I think Darren was saying earlier, I don't think there's going to be that much exposure because causation is going to be really difficult to prove that they actually got the virus from the pool area. So I'm not as concerned about that. And frankly, I don't want board members getting into fistfights with homeowners trying to enforce some of these requirements.
And that is going to be the weird part about this is there's just so many unknowns. Like we were saying, the liability risk on an open area like a swimming pool area should be substantially less than, say, a clubhouse.
Right.
Opening your clubhouse is probably going to be one of the most difficult things. I noticed one of the comments was, what the issue of associations risk is that most, if not all, of our insurance policies exclude infectious disease as an insured risk. So that means if the association gets into one of these difficult situations, say they open their clubhouse against the county order, and someone was to contract the illness, well, it will be difficult for that person to prove causation and liability for the association. One of our concerns is it'll probably be one of the most expensive lawsuits you've ever seen.
Right.
Because it's going to require experts in infectious disease and thinking about that these may be, because a lot of attorneys out there make their living on these types of claims. Those experts are probably going to be some of the most expensive experts we've ever seen. And so it is mindful to think about when you're thinking about common area. Think about a very clear distinction between the open spaces where there's fresh air, et cetera, and the enclosed spaces. And thinking about those very differently, I think, is important for boards as they move forward, because while there is more likely than not less risk in the open spaces where there's air and circulation and more distance between folks, opening our clubhouses, I think, is going to be much more difficult.
I want to pick up on something there that Darren said, and that is if you're opening it contrary to the county's orders, then I think you've got a problem.
Yes,
Because if you do end up in a lawsuit, you're going into court with the mark against you, and a jury's not going to be sympathetic that you violated the health orders by opening up your clubhouse, and they may decide they want to punish you, even if it's tenuous, the evidence that they actually caught the virus there.
Yeah, I think that's exactly right. In monitoring the county orders is going to be crucial as we proceed. And as I keep saying to folks, we are going to see these evolving daily almost. And it's going to be very difficult to keep up. And also being mindful that we could also see county orders changing where we have to reclose certain facilities even after we open them. And that's something to be mindful of, is that these orders could change the other direction where we're ordered to immediately shut things down.
Right. It is a changing living assessment we have to make here. So let's move on from the pool question, which I'm glad we got to first. Lots of questions about the pools and amenities and other clubhouses. Here's a question that I think is interesting, and it's a bit of a segue into from what we were just talking about. What are the top few emergency resolutions that boards of directors are adopting due to the effects of the pandemic? Who wants to take that? Anybody seeing emergency resolutions from boards?
One we're seeing a lot of is closing common area facilities to guests and limiting use of common area to residents only. That's a big one that we're seeing a lot of communities do. And
wearing the face masks in the common areas, limiting the number of people in elevators, limiting the number of people in particular areas, those kinds of emergency rules that we're seeing.
I think the biggest one that I have seen is the use of Zoom for board meetings. People haven't been necessarily getting together to hold in-person board meetings, and then, which I'm fairly comfortable with that, but then the follow-on to that is that there are plenty of elections that are now being held via Zoom, and that's definitely a little bit, I think, more dangerous. But everybody is coming to us asking us if they can do away with the in-person board meetings. And I think it's a good idea, particularly in some areas.
Well, and that's something where it'd be nice to see some legislation. Perhaps, CLAC, I'm one of the delegates with CLAC, and I also serve on the executive committee, is looking at, is it possible for us to make this a permanent condition where we could meet regularly and consistently into the future remotely and not having to have a designated location. So that's something else to be thinking about, is there might be legislation in the next few years where this could become the norm, and making it, in a lot of ways, making it easier for boards to meet, which I think is a benefit for everybody. And that member participation, I don't know if you guys are seeing this and chime in but we're seeing a lot higher level of participation by our membership at board meetings because they can just attend from their home. And that's a wonderful, you might say democratizing force that's beneficial to all members.
Good. Personally, I've seen a lot of Zoom meetings going on. We have many boards that have agreed to do that. And so far, the response has been tremendous. Homeowners, even more homeowners are joining Zoom meetings than would come to a meeting that was actually held in their community. So it's an interesting development.
And
really.
we're calling them Zoom meetings. I've participated in maybe half a dozen different platforms on video conferences. And I can tell you, though, that the Zoom meetings are probably the easiest and the most used by homeowners, by boards out there.
Yeah, because they're free. But anyway, that's just my opinion. I agree with you, Adrian. There's lots of different ways to do it. So anything online that can help together and talk about some of these issues, I think is very productive and beneficial. So let's move on to an interesting question about delinquencies and delinquent accounts. Two pieces to this question from separate people. What's your feeling on how to move forward with the Eastern Bankruptcy District's ruling, which said association liens were no longer a continuing lien on the property? And secondly, what are the do's and don'ts of borrowing money from your reserves if you have some operating fund shortfalls because of delinquencies?
Okay, well, I can't address the bankruptcy issue. I don't do collections. But as far as the reserve borrowing, you've got to follow the statute, give notice to the members, do the resolution in the minutes, decide, let them know why you're doing it and when you're going to repay it. The other option is to simply stop making transfers into reserves, which is not a borrowing per the statute. It's strict reading the statute doesn't make it a borrowing. However, I would encourage the same, that you notify the members, that you have a resolution in the minutes explaining why you're doing it, and then when and how you're going to resume contributions back into the reserves.
Yeah, and that should be a discussion at an open board meeting as part of your budgetary discussion.
Right.
And making sure that the members are aware of what the board is doing in terms of finances. This is, again, one of those times when transparency is going to be crucial. People, the expectation is always that assessments will just go down every year for some reason while everything gets more expensive, especially, we've talked about the pools, right? Pool opening is going to be expensive most likely in the early stages, trying to figure everything out and getting it right. You may have to be reevaluating your budgets pretty dramatically over the next few years.
Right. Anyone have any opinions or information about the association liens and what the decisions in the Eastern Bankruptcy Courts might mean?
I hate to say it, Jeff, that's probably too specific of a question for any of us should be answering. Okay. Because of the nature of the uniqueness of the claims and the uniqueness of that bankruptcy court's orders. It's going to be driven very much by those particular circumstances for that particular client.
Yeah, it's in conflict with other case law, so it's really problematic, and I don't know that we can properly address it here.
Well, I think that's information that's really helpful, Adrian. I didn't know that myself, so I think stand by and watch as those cases progress and try and find some clarity in the case law once we get through this. So.
Associations should be working with all of their homeowners who are experiencing financial difficulty to come up with a payment plan and work something out. I mean, we shouldn't be thinking about leaning and foreclosing right now. We should be trying to work with everyone because most people will eventually have the wherewithal to catch up on their assessments. So I think the first approach should be talk to the owners about a payment plan, talk to them about their situation. And I realize the flip side of that is the association has bills to pay and they need the money to operate. But people are in a very desperate situation. And usually they want to pay, they're willing to pay, they just need a little more time to get back to work. So we've been working out a lot of payment plans with our homeowners, and that's been very effective to keeping peace and harmony in the association. And I think the association will eventually get their money under those plans.
I have a little bit
Further to
different
that-
view on that. I think there should be liens placed in order to protect the association, because there's 39 million people on unemployment right now, and a lot of these companies that they work for are never coming back. And so you're going to have people who may not ever get their jobs back and may at some point declare bankruptcy. And if you don't have a lien in place, you've got no protection for the association. But I agree, you should work out payment plans. You should be generous in the payment plans and allowing people to try and get something reasonable so that they can stay afloat until they get back on their feet and then start paying regular assessments plus whatever the payment plan is.
And one thing that you can do is there are plenty of associations that have adopted a policy during this time period that they are not assessing late fees so long as there is a payment plan that's been entered into, and that provides a vehicle for both the association and the owner to demonstrate that they are, acting in good faith and trying to handle the unfortunate situation.
Wonderful, thank you. I have a couple of people asking the same question, so I'd like to just jump back a little bit to the conversation we had about hosting online meetings, Zoom meetings, and those types of things. I understand that typically attorneys would probably in general say don't record meetings. I think we have a new opportunity here where boards are going to want to consider that. And does the fact that we're doing meetings by Zoom change any of your opinions, or if we're in favor of it, would you like to make a comment about that? Some boards are really thinking they should be recording some of these meetings.
Yeah, well, I used to be opposed to them, and I'm still opposed to recordings if it's a non-Zoom meeting. But I'm kind of shifting my position on Zoom meetings, because if owners are recording them in some way, doing screen capture, and suddenly your meeting is edited and put on the internet, and you don't have a recording yourself to show what the actual meeting was, then I think it puts you at a disadvantage. The downside to having the recordings is that, of course, they can be subpoenaed in the event there's litigation, and then you've got to produce them. But as long as everybody's behaving themselves, that shouldn't be a problem.
And I would agree with Adrian on that. In the past, we've always taken the position of, recordings typically not preferred because it does, people are concerned. I'm being recorded. I don't want to say my truth, so to speak. Or I don't want to express myself because I'm afraid of retribution. But with Zoom meetings and the nature of these, it does, I agree with Adrian, it's very appropriate for us to be recording them as associations so that we have a record as well. Because we should presume that other folks may be recording those meetings, and you never know, people could manipulate or whatever those types of recordings. And I just saw a question. Do you have to announce that you are recording? Yes, 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 you do.
Yes.
This is a state that requires the parties to consent to the recording, and there should be, like we did with the beginning of this call. I joked with my panelists before we began that I have my little disclaimer form here that I read from earlier. We might want to think about something like that at the very beginning of the meeting, where we're making a formal statement that this meeting is being recorded, that we will retain a copy of it for a fixed period of time, et cetera. And so working with your own counsel to develop what sort of strategy should we be using to let people know what we're doing in terms of recording these meetings.
The answer to whether or not recording an open meeting is a good idea. That answer might be very different if the question is with regard to executive sessions, because yeah, I would be uncomfortable knowing that the executive session meetings are being recorded while I'm giving legal advice, and then the question arises whether or not that recording is something that can be produced later during the course of litigation, or is going to be required to be produced.
Yeah, it's a very true statement.
Right. Any other comments on that? Nope. I'm scrolling through lots of questions. Thank you everyone for submitting. Some of them I will be able to get to, some of them I won't. I want to bring Roger's expertise to the forefront here with the question. Has the SB 326 or SB 800 warranty timelines been adjusted due to the shelter-in-place orders?
The construction defect timelines have not been adjusted due to the shelter-in-place orders. So if you have a construction defect and you have a statute of limitations approaching, there's nothing that's stopping you from getting an SB 800 notice out. That's simply a notice prepared by an attorney that's served by certified mail. So that can still go out, and they have been going out during the shelter-in-place order. It's a little different when you have to file a lawsuit and the court is closed. Some county courts are not accepting new filings because they're closed and there's no one there. So in those situations, the courts have issued an order that there will be an extension on statute of limitations if you're unable to file due to the court's closure. But a lot of courts are still accepting filings, so it's going to depend on the court in your respective county. But if you do have a construction defect claim, and we've gotten some new ones during the closure and we've moved forward with them, I would not presume that there is an extension or that the statute of limitations is going to be waived. I'd move forward with that notice and consult directly with your court if you need to file a lawsuit, and find out if they're accepting filings, and if not, whether they will extend that timeline.
Information. Any other comments on that? I know that's not an area of specialty for everybody.
Well, I agree with Roger 100%. It's a good segue though into what happens with construction projects, during the course of this crisis. And I think that at least the county orders are not all that contradictory. The counties that have adopted construction related orders are all pretty close to the order that has been issued by the state. But if you are doing capital improvements, if you are doing destructive testing on a large scale, if you are doing a reconstruction job, any project that isn't being conducted by a homeowner to that homeowner's project home, any project like that is going to require compliance with a county order. And I think you need to involve your attorney. You need to make sure that the contractor that you're hiring has a COVID-19 procedure in place. And it's the cost with regard to construction projects is absolutely going to increase during this period. The orders are basically a minimum of 4 pages, and they go up to 10 pages. And there are some pretty strict requirements. And so I encourage everybody to talk to their lawyer before they do a construction project.
Allison, let me just expand on that just for a second. There's a question about procedures to allow staff to return to perform maintenance. I'm assuming that's on-site staff. Do you have any comments about that?
Well, it depends if you're an employee or if you're not an employee. If you are subcontracted, if an association has contracted work out, then I believe that you would have to comply if it's construction work with the construction orders, and they are complicated. In addition to the things that we are seeing, like use of PPE and social distancing, the orders require that that you bring all of your people on site at the same time, that everybody is monitored through use of taking temperature and asking the same types of questions that everybody's heard at the supermarket. The contractor's got to install hand washing stations. There has to be a designated COVID-19 supervisor. And you might only have 5 people out there doing some small construction project, but you still have to have this COVID-19 supervisor that is running through all of the requirements and rules with the employees on a daily basis. If somebody, if we become aware that somebody has coronavirus while they were on the project site, you literally have to call somebody that's been certified in hazmat cleanup to come out and to disinfect the area where the work is being performed. There needs to be separation between the residential owners and the individuals that are performing work in somebody's unit or home. And so construction projects for the time being are going to look a little bit more like mold remediation, where people are in full gear and where there's protective sheeting separating owners from the contractors. It's pretty complicated.
Jeff, let me jump in on that.
Your question is, it depends.
Make it broader.
Thank you.
Make it broader into just general the vendors. So like the landscapers and pool maintenance people, those vendors, the association lets them do their job. They're going to do it the way they want to do it. I wouldn't interfere with them unless it's something where they're becoming too close to homeowners and employees. Employees are a little more difficult because they're your direct employees, got potential workers' comp issues, and you want to make sure that you're making providing them safe environment to work. So the face mask, the social distancing, where appropriate, maybe disposable gloves. This is really important in the high rises that we work with, but the larger associations with staffing issues, some of them have laid off their staff, like the valet, because you don't want the valet to be in people's cars. And because of the potential that creates potential exposure issues there. So it just depends on whether it's a vendor that you're working with or whether your own employees, and there's where you want to make sure you're following proper guidelines, and you maybe want to talk to legal counsel on what those guidelines are.
And then building on that too, on Adrian's point, is making sure that our contracts on outside vendors are requiring that the contractor comply with all laws, orders, et cetera. So that that way we have the protection for the association to say, well, that was the contractor's responsibility. We agreed that they would be the ones that would comply with these requirements. And so that gives the association a level of protection that it can say, we agreed, you're going to do these things. You're going to comply with the public health orders, the law, et cetera. And so if you fail that on your part, vendor, it is not the association's responsibility.
I agree.
Scrolling through here, still some questions about liens.
We have a question
Debts.
on, there was a kind of an odd one. The secretary records the meetings for in-person. So we were talking about recording earlier, board meetings. You know, I think fundamentally, and correct me if the panel has any other thoughts, but I think fundamentally the board could choose not to record a meeting just as easily, and you rely on its minutes from the video conference meeting just as it would at an in-person meeting, just to kind of address that point as well. It's the board's discretion to decide whether to record its meetings. Even when you record meetings, you're still going to be keeping minutes, right? So the minutes are that reflect the actions of the board. And so that's going to be key to that as well. You know, just kind of following back onto the meeting issue.
So a question, I'm sorry, Roger.
I want to make a comment about board discretion with regard to reopening, because a lot of people are under the impression that just because the county order says you can reopen, that you have to reopen these facilities. And you don't. The board should exercise a standard of care, exercise the business judgment rule. I think if you're going to reopen a pool or a clubhouse, you then have a heightened duty to keep cleanliness and to control how many people are gathering in those facilities. And I know there's a lot of pressure anytime something's closed. Some people are very vocal and say, open the pool, open the pool. But just because the county allows it doesn't necessarily mean that you have to immediately open that facility. There should be consultation with an attorney, consultation with experts, and a plan in place before the board decides to open that facility. You have to feel very comfortable with doing that and go through all your standard of care procedures and your business judgment rule procedures. Don't just jump into opening just because the county says you can.
And building on that too is thinking about, limiting hours of operation, because one of the big things I'm seeing is that folks, heck, I'm looking for cleaning wipes, right? So if anybody has access to cleaning wipes, let me know. I've not been able to find them. And I think that we're going to be pressed with that in associations. The county orders will probably dictate a very particular method or a cleaning requirement. How are we going to meet those requirements? And I think Roger's very right on point in saying we need to be thinking about these things. Can we actually do what is required to meet that minimum standard of care?
And I'll add to that too, if you're going to assume a duty, and such as opening up pools and clubhouse, you need to do it in a non-negligent manner. And so if you open up the clubhouse and decide you don't want anybody touching any doors, and you block open all of the fire doors, I think you create a problem for yourself, because if there's a fire and all the fire doors are open, there's going to be liability. So anything that you do needs to be done in a non-negligent manner.
Correct.
Very good point.
Lots of signs.
Yes.
Lots of communication and newsletters and online and email blasts. Communication's the key. Here's a question that I think is a good one. Is it legal or reasonable for a board to require that comments from open forum in a Zoom board meeting be required to be provided by a deadline in advance of the meeting, and limited to any specific word length that approximately represents 3 minutes, and should be perhaps read into the record by the board?
So in other words, that's the way they'd handle the open forum. So instead of having
right.
an open forum where people can actually talk to the board, require that it be submitted in advance as questions.
Right.
I suppose it could be done. I don't know that it would be deemed reasonable anymore, because it's so easy to do open forums in a Zoom meeting. So you open it up, let people speak, and then you close it, and then you conduct your meeting. So I don't know how a judge would rule on that, whether you consider it reasonable to shut down the open forum and require people to submit things in advance.
Yeah, I have a feeling that most courts would find that to be an unreasonable restriction on speech, mainly because not everybody, the arguments would be not everybody has a computer, say, right? You have a right to attend a board meeting. You have a right to speak at that board meeting on any subject matter you choose to speak on. And to say to somebody, no, it must be done in writing, it must be done by a deadline, I think that would be very problematic. You could always tell people that, right? You could say, we'd like to hear your comments in writing in advance. I don't know that I would include them in the minutes of that board meeting, because who knows what the context is going to be or what the statements are. But it is helpful to have those statements in writing. But I think it would be in conjunction with also allowing members to speak a reasonable time period during the open meeting.
There you have it. We have one question here that seems a bit specific in some cases, in some ways, but I'll try and ask it anyway. Talking about the potential PG&E safety shutdowns that are starting up again this summer. One of the community managers asks, we are starting to get questions from individuals wanting to install or use emergency generators in multifamily communities where concerns of building fire hazards and noise or noxious fumes effect on neighbors may be a factor. This is a potential issue that's pretty new. If people remain limited in their ability to get outside, cool themselves at alternate locations and or have health issues requiring powered equipment, they may claim that generators are a health or safety requirement. Any ideas on how associations may navigate the balance between community safety and individuals' need for power?
Well, think
Sorry,
about,
no, that's a long
we're
one.
gonna kind of draw, I'm gonna draw a distinction. My panelists can correct me if they don't like the distinction, but the distinction would be is somebody that needs it as a disability accommodation or medical necessity. I'll just use the example. I know someone that has a heart valve that requires electricity in order to power a pump that keeps the person alive. And in that setting, for an association to say you cannot have a generator would be very problematic. And so that would be a discussion between the board, their council, management. How are we going to address that issue? The other, taking that aside, so we're going to take the disability or the health condition away from this discussion. We're not going to discuss that anymore because that is an exclusive area where we're always going to want to meet that requirement. As to the other ones, we'd have to look at adopting rules. And how can this be done? How would it be done? Is it in the best interest of the association? Applying those standard discretionary considerations that Roger was talking about before, to make sure that we're doing the right thing, to make sure that we can manage the installation of generators so that people have power settings and the ability to have power. It's going to be a difficult situation for each community. And then if there are rules adopted, how are we going to enforce them? What level of enforcement are we going to exercise, et cetera?
I'll add to that. It's going to depend also on the type of construction that you're looking at. Condominiums, then you've got all common area. The board controls that. And where do you put a generator for an individual owner that wants to install one? It seems that that's not going to, you're not going to have that situation where they're going to be approved. Whereas perhaps in a rural setting where there's a lot of power failures, and it's a townhouse construction, and they own the lot. Okay, now you're regulating maybe the size and the noise levels of the generator, and then versus whether it's single family homes and whether they're going to install on their own lots. I don't know that you can stop them, but you can certainly control the sound, the nuisance noise issues, and exhaust from them. So, and generators come in all sizes, and some of them are quite large and some of them very small. And the noise levels on some of them are quite different. So it will depend on the particular situation where this comes up.
Yeah, and there's all, as Adrian's saying, there's all different models. We have communities that will allow, for example, propane run generators, but prohibit, for example, diesel or other liquid gases to be used. We've seen battery powered ones, all different manners. And so it's really a matter of evaluating, you know, the mechanics of what is the rule going to allow, spacing on the lots, especially when you have attached townhomes, right, where the owner owns the physical lot where the home is located. You know, is there actually spacing on that lot to place a generator? There's many issues that would have to be addressed on a case by case basis in those circumstances.
Yeah, I had responded to the person who asked that question that it was likely going to be seen as pretty specific, but I think you guys did a good job of separating out some of the core issues and providing good advice. Thank you for that. Okay, we've got a few minutes left here. I think it's 12:30. I've got one or two more questions here. Here's an interesting one that I'm not sure any of you will be able to help on, but I thought it would be applicable because of the discussion about Zoom meetings a little earlier. We have a question that asks how we prevent non-members from attending board meetings through Zoom. And if you have any, I don't know if any of you are Zoom experts, but I know you've definitely been attending a lot.
It depends on how they're attending. If they're attending directly, you can block them. Because if you can identify them, you can block them. But if they're sitting in the same room with somebody who can attend and you just don't see them on screen, there's no way of stopping that.
Sure, correct.
You can say in advance that there are no, non-owners not allowed, but frankly, you can't really monitor it.
It's particularly a problem with executive sessions,
right?
Which are supposed to be board members only, and now you've got the board members' families standing there in front of the computer and you can see them sometimes watching the executive session.
Sure.
And we had to admonish someone the other day and say, you know, this is really just for board members. Your friends who we can see on the screen have to leave. But it's very, very difficult to prevent.
Correct, and that's always going to be a tremendous issue in those types of settings. I mean, even on a conference call, you have the same problem. You don't know who's in the background listening on the speakerphone to the entire conversation. But you know, part of that is also reminding folks their obligations to the community, right? As a director, your obligations are far higher, and your duty of care is much higher. And so most folks that we run into generally go, I just didn't realize or didn't think about that, and it's corrected pretty quickly.
Good advice.
Jeff, I wanted to make a general statement about COVID-19, if I may.
Please.
A lot of people are very cavalier about this virus, and most of us don't think we're going to get it, particularly young people. I've heard them say, you know, it's not going to kill me. I don't care if I get it. I'm still going out. I'm still going to mix with my friends. And most of us don't know anyone who had it. I actually do have a few friends and acquaintances who have been severely affected by it. And I wanted to just point that out to show the seriousness of it. My friend who's a police officer, very healthy man, was taken off his feet by it. He was in the hospital for a week. He finally recovered. His wife is still suffering greatly and almost died from it. I did have an elderly friend who died almost as soon as he started showing symptoms. And I have another friend who had it and was asymptomatic, didn't have a single thing affect them, although they tested positive. So I just wanted to emphasize how severe it can be for some people. And it's easy to get cavalier about it and not worry so much about it, particularly as things are reopening and we start going out again. But keep in mind that it can be deadly. And particularly if you're an elderly community, I think you may have a heightened duty to your membership to take extra precautions.
Thank you, Roger. That's very moving. I know I've known several people who've had the disease. One of my board members for an association we manage in Washington State died early on in the process. And it's been devastating to the people that he knew, and he was on the board, president of the board. It's definitely, and we're getting some comments now from people with similar stories. One member talked about her son who's 20 years old who had it and suffered for 5 weeks. So it's not just the old and the infirm, clearly. So I appreciate you bringing the importance of all the things that we've been trying to do for the last 3 months to light. And if I can just insert my own personal opinion here, I would say it's foolish to think that that it's not going to affect you. It can affect you in so many different ways. You not personally, perhaps, but acquaintances, family, and friends. So let's all be very, very careful.
Yeah, Jeff, I want to add something on a separate note before I forget it. Some of the admonitions that that Darren was talking about, you know, in dealing with the meetings and these meetings and who attends and who doesn't attend, is that sometimes it's easy for boards to forget to announce in advance that you can't record the meetings, that only members can attend, and those kinds of things. You might just put that as standard language in the notice of meetings and in the agenda. So you've got it in writing that you can refer to if you need to, if something comes up, but it also serves as a reminder to everybody what the limitations are on their ability to attend these meetings.
Right.
Absolutely. And
Right.
The more notices we get out in advance, the better off we are in most circumstances. So doing that as part of the agenda that we'll be recording it or not recording it, good things to do.
Those are good strategies to prevent people who are not supposed to attend from logging in. But again, like you said earlier, Adrian, you can't stop someone from looking over somebody else's shoulder or being in the same room and attending the meeting vicariously that way. But control the things that you can control and deal with the other things, I think, separately is a smart way to deal with it. One question here, I think we've got about 10 minutes left, a little bit less. This is a question I think that other people probably would like to know the answer to. Do we need to adopt an emergency resolution in order to hold an annual meeting via Zoom? And I know your answer is going to be look at your documents, but are there any general responses or
An
opinions?
emergency
about
resolution? I would just announce it. I don't know
Yeah.
that you need to have an emergency resolution. You just say, we're going to have an annual meeting, we're going to do it by Zoom.
that? Right.
Because remember that when we do an annual or a member meeting or an annual member meeting, it is a different notice requirement from a board meeting, right? So we're going to be giving at least 10 days notice of that meeting. In that notice, so the board would, because who calls the annual member meeting? It's either the board of directors, typically looking at your governing documents, or it could be the membership. In either circumstance, you'll be having to give notice of the date, time, location of that meeting at least 10 days before the annual member meeting. And that's individual notice to each member of the association. It's not just a general notice statement. And so that gives you a good position where you can advise people, this is how we're going to be meeting. It will be by Zoom. One of the key things is if it's a member meeting, do we have the capacity to have every member dialing in, right? Do we want to save $5 or $10 and do the 50-person Zoom meeting? We should be expanding maybe to the 1,000. What do we do in a community with more than 1,000? You'll have to figure that out with working with your council and management to see how we can manage that. But it really would just be a matter of the board making the determination at a board meeting and then announcing that to its membership.
Right. And so along those lines, I'm not an attorney, but I'm going to make sure everybody understands that you still can't do voting or balloting on an annual meeting. If you held your elections during your annual meeting, can you still open ballots that have been properly collected at an annual meeting by Zoom?
Well, you can have a camera trained on the inspectors so that people can see them opening up the
Right.
ballots and counting. So that works.
Does anybody feel uncomfortable about that?
I don't.
Only if the camera moves off the ballots. So long as everyone that's on the call or I feel like we're selling Zoom today, but if you're on the video conferencing platform and everyone is able to see the inspector of elections doing their work, and I think it's one of those times too, is going back to Adrian's point, this is a good time to record.
Mm-hmm.
Record the conference so that everyone at
Right.
some future date, if there's a challenge, we can say, look, here's the video. This is what everyone was able to see during the entire process. There was no tomfoolery or tricks going on. And we did the best we could under the circumstances. And I think that's a lot of what we're going to be arguing if there are challenges to that is, did we do the best we could in fairness to our membership and as best we could comply with the law under these horrible circumstances?
Yeah, and this is where you take the camera, instead of somebody holding it and trying to, record it, you put it on a tripod. And so it's got a fixed position, it's not going to move, and it's recording what's happening in the people opening up and counting the ballots.
Yeah, absolutely.
So I'm going to turn this question into a comment, which I think is really smart. We were talking about logging executive sessions where we weren't sure who was attending, and so one of the members suggested that you have a separate login, or some platforms actually have a breakout room for the executive meeting and then a waiting room to permit people to come in. And so there's two options there for you to at least be able to control who's at your executive session meeting a little bit better. What you shouldn't do is continue right on from the general board meeting using the same conference, because you can tell who's hung up, but if it's a phone number, you don't necessarily know who that is. So just a little good point there from Cynthia.
Yeah, typically we advise on executive session that you use a separate call-in number.
Right.
If you're using a conference call, or if you're using Zoom meetings, that you end the open session fully and completely, adjourn everyone, and then have the board rejoin into executive session. It's actually one of the benefits if you start before the meeting, do the executive session before the open meeting. That can be a tremendous benefit, make it easier because you know exactly who's on at that point. And then once you close your executive and you members are starting to dial in, it's pretty clear distinction between the two that way.
Very good. So I think we've gotten to the point where we're using Zoom like we're using Kleenex.
We like to call them video conferencing platforms, Jeff. So.
About VCPs, Darren, because we're all about acronyms, right?
Yes.
Right.
Hey, and I want to answer, hey, Jeff, I just saw a question that came up that's near and dear to my heart and wanted to answer.
I was just going to get to that, Darren. I knew you were looking at it.
Oh, very good, Jeff. There we go.
Here's the question. Is there any hope that this provision about the Inspector of Elections from SB 323 will be reversed by the legislature this year? Darren, can I call on you?
Yeah, is my head dropping the answer? No.
Not a chance.
Unfortunately, we're not going to see any hope for that this year. You know, the legislature, one, they have other priorities that they're focusing on. I don't foresee any change. There's no bills that have been introduced that are going anywhere. And so my hope is, fingers crossed, they'll be looking at perhaps next year, reevaluating what SB 323 has done, the costs, the expense, the headaches. And maybe there's a way to make it better and make the community better.
Any other comments, Adrian? I thought you were.
I'm in favor of rescinding it. I'm going to be pushing for complete rescinding that bill. It may be pipe dream, but I'd like to put a lot of pressure on doing that so that maybe we can get some good reforms on that bill.
Right. I don't know if Louis is still with us, but if he is, he's welcome to come and come back online here for a second. Rachel, do you know if Louis is still here?
He is still here. I don't know if he
may have left the room.
He's here, but
he's paying attention.
Yeah. Louis.
Yeah, I like to say, we don't foresee any action on this year. You know, I think there could be some benefits in terms of, you know, maybe in uncontested elections, expanding that. You know, there's a lot of things, a lot of ways. I mean, I agree with Adrian saying, you know, it'd be nice to not have to do it because there's really been no reason to do what SB 323 did. But I'll let Louis build on this concept.
No, I'm right with you, Darren, and I think you're right on. The chance of getting legislation done this year is somewhere between slim and none. There may be, and just because of the issues that we're having to deal with now as related to COVID, I think it could give us the opportunity to make stronger cases next year in a cleanup measure to address some of the issues that we were already talking about with the author on their cleanup bill, but add some of them like this because we now have a real experience at the complications that 323 created.
Yeah, and so that's something to think about too, is if you have a bad experience or the costs, because that's, I think, something that we could push on, is potentially that in essence, this new law is going to bankrupt communities. And as I always like to remind the legislature, a lot of our associations are the entry-level communities. Condominiums are affordable housing. And keeping in mind that these types of laws are making affordable housing unaffordable. And if you have information or things that have occurred in your community, communicating that to CLAC is most helpful because we can use those as examples for why the law needs to be changed, how it's impacting folks negatively.
And that's another reason to have those calls and these outreach meetings with legislators right now. As these experiences are occurring, we're educating them on the spot, the damage that's happening, that then just builds our arguments when we come back with official legislation.
Right. Thanks, Louis. Thanks for your input. Thanks, everybody. I think we're going to wrap it up here. Hello, Rachel.
Hi. Thank you guys so much.
I want to just say one more thing. It's been a real pleasure and an honor helping to get through this first educational seminar. I think it went extremely well. You were all very well behaved and polite. Thank you very much. Great questions. Good interaction in the chat room. It was a privilege, and we from the chapter and the board really want to extend our appreciation to all of you. I see 89 non-video participants and 7 of us on video, so 96 or something like that.
Yeah.
Very nicely done. Thank you very much, everybody. I hope you enjoyed yourself. Rachel.
Don't go anywhere. Okay.
Rachel will finish us off. And we have a networking session to go to.
Yes, we do. Don't go anywhere yet. First, we want to say a big thank you to our speakers. So once I get to the end of my little spiel, you can go off of mute and clap and then put your video on and we can do the networking. But first off, so much thank you to our speakers. Thank you to our sponsors. We really could not do this without you, especially our registration sponsors and our marketing sponsors. You know, they're the ones who get you guys here into the door, and we really appreciate it. Also, our next digital program is going to be on June 18th. It's a Thursday, and you will be getting a survey about this one. So if you could please let us know, you know, if there was anything that you would like to see, you know, changed in terms of communication. Did you get your Zoom information all right? You know, do you want it more in advance, etc.? Just let us know. You know, we'll make it work. And then that's all I have. So if you want to stay for the networking portion, feel free to turn your video on and unmute, and we're going to do a little clap for the speakers. Here they come. Yay! Unmute your, I can't unmute anyone. I can only mute all. Thank you, speakers.
Great job.
Thank you.